I've defended over 5,000 lawsuits, and let me tell you this, the people who win and the people who lose usually get separated in the first 48 hours. Two business owners can get served the exact same lawsuit on the exact same day. One walks away in 30 days, the other loses everything, even his house. The difference came down to speed and strategy. The very first moves, and they take less than 2 hours to complete. I'm Santiago Cueto, a board-certified international business attorney and best-selling author. I help companies deal with lawsuits every day. This isn't legal advice for your exact case, but it will help you move the right way right now. Start by reading the papers, not skimming. Read. You're looking for the summons and the complaint. The summons tell you which court you're in and your deadline to respond. The complaint says who is suing you, what they claim you did, and what they want. If you don't see a summons, check the first page again. It's usually at the top. If the document looks odd or the names are wrong, call the clerk of court and confirm the case number. Scams do exist. Don't pay anyone over the phone. Now mark the response deadline on your calendar. Put it in your phone. Set reminders. The deadline can be short. Think a few weeks, not months. If you miss it, the other side can ask for a default. That's like losing before you even talk. If you think you're going to cut it close, a lawyer can often get you a short extension, but don't count on it without asking. Hit pause on public comments. Don't post about the case. Don't text your friends about it. Don't email long rants. Anything you write can end up as evidence. If you run a business, tell your team to route any questions to you or your lawyer. One voice, one message, no debates on Slack or WhatsApp. Protect the evidence. This part is not optional. Keep emails, texts, invoices, photos, and messages. Don't delete anything. Turn off auto-delete on chat apps. And if there are paper files, put them in a safe place. If you have a company, send a short note to your staff telling them to keep relevant documents and not to overwrite or wipe any devices. Lawyers call this a legal hold. You don't need the fancy label, you just need to keep the records intact. Next, call your insurance agent. Don't wait. Many business and homeowner policies cover defense costs for certain claims. General liability, professional liability, D&O, and EPLI. These can pay for a lawyer and sometimes even settlements. Coverage depends on the policy, the claim, and how fast you report it. Late notice can hurt you. And ask how to tender the claim in writing. Get a claim number. Save the email confirming they received it. Next, choose a lawyer who does this type of case in this type of court. If it's a contract dispute, find a litigator who handles contracts. If it's employment, pick someone who lives in that world. If your insurance assigns a lawyer, meet them early, share the documents, and ask how the insurer handles strategy and settlements. If you're hiring on your own, bring the complaint, the summons, and the contract at issue, and a short timeline of what happened. Ask 3 simple questions. What do we have to do next? What could win this fast? And what will this cost in the first 60 days? Build your timeline. Keep it simple. Dates, what happened, who is involved, and where the proof lives. If money is involved, add amounts and attach the invoices or bank records that match them. Don't write a novel. Make it something your lawyer can scan in 5 minutes and say, I get it. Check for contract terms that change the playing field. Look for arbitration clauses, mediation clauses, or form selection clauses. If your contract says disputes must go to arbitration, you may need to ask the court to move the case. If you answer the complaint without raising it, you can waive that right to arbitration. This is why reading your contract early matters. Hand the contract to your lawyer on day 1. Look at who they sued. Is it you personally, your LLC, or both? Are the names spelled right? Are they claiming something you actually did or something your vendor did? Details like this can lead to early defenses. Sometimes the plaintiffs sue the wrong entity or used the wrong theory. That can open up the door to a quick motion to dismiss or narrow the case. Think about where the case sits. Some disputes can be moved to federal court, but the window to remove is tight. If that move helps you, you have to act fast. Don't guess. Ask your lawyer on the first call whether removal is on the table. Next, plan the first response. You usually have two main paths to start. File an answer with defenses or file a motion that attacks the complaint. There are good reasons for both. If the complaint is sloppy, a motion might knock it out or force a cleaner version. If the facts are clear and you need to tell your side, an answer gets you moving to discovery. What you don't want is silence. Silence gets you defaulted. While that's happening, check the math. If they want money, what is the real exposure? What would it cost to fight this for 6 months? What would it cost to fight it for a year? Compare that to a business solution. This isn't weakness, it's math. Plenty of cases settle early because it's the smart move, not because someone gave in. Ask your lawyer about early settlement talks or mediation. Early can mean before you spend big on discovery. You also want to protect your communications. If you're working with a lawyer, keep your strategy talks between you and your legal team. Don't forward your lawyer's emails to outside people. Don't CC your whole company. Attorney-client privilege is strongest when you keep the circle tight. If you need a consultant or accountant to help, involve them through your lawyer so the privilege stays intact. Be careful with opposing counsel. If the other side has a lawyer, do not reach out directly to the plaintiff or their executives. Channel everything through the attorneys. Keep it professional, no angry emails, no threats. Judges see those. Juries see those. They never help. You also want to take care of your people. If you're an employer, don't retaliate against any employee who might be a witness. Don't cut someone out of meetings or slash hours because they're involved. That can create new claims. Set one point of contact for the case, usually you or your general counsel. Tell the team the basics. We're handling it. Here's who to send the documents to. Don't delete anything and don't talk about the case outside. You also want to manage vendors and customers. If the lawsuit could spill into operations, prepare short, calm language that you can use if someone asks. And keep it simple. We're aware of the claim. It's being handled. Our services continue as normal. You don't owe the world your strategy. You also want to watch for quick deadlines after the first filing. Some courts require initial disclosures, scheduling reports, or a case management plan. Mediation might be ordered early also. Missing these can annoy the judge and put you on the back foot. Put dates in the calendar as soon as you know them. Handle subpoenas carefully. If you were served with a subpoena instead of a lawsuit, the steps are different. You'll still need to read it, keep evidence, and talk to a lawyer. Subpoenas have tight deadlines, so don't ignore them. If the request is too broad or seeks private data, your lawyer can negotiate or ask the court to limit it. If you already missed a deadline, don't hide. Tell your lawyer today. Courts often allow a default to be set aside if you move quickly and have a real excuse. Time matters here. Hours can matter. You also want to keep perspective. Look, lawsuits feel personal, but the system runs on paper, deadlines, and proof. Your job is to be organized, responsive, and steady. Your lawyer's job is to push the right buttons in the right order. Let me give you a simple plan you can follow today. Put the deadline in your calendar. Create a folder, digital or paper, where every document and email goes. Write a one-page timeline. Call your insurer and file a claim if your policy might apply. Book a consult with a qualified attorney in your jurisdiction. And ask about early defenses, removal, arbitration, and a budget for those first 60 days. Decide whether to aim for an early resolution or prepare for a longer fight, and why. One last thing about cost. Look, lawsuits are expensive because time is expensive. Anything you can do to shorten the path helps you and your lawyer. Clear documents, clear timelines, fast responses, focused goals. All of that saves money. You're not the first person to get served, and you won't be the last. What separates a bad outcome from a good one is usually speed, honesty, and a plan. Read the papers, keep the evidence, call your insurer. Hire the right lawyer, move with purpose. If you found this helpful, subscribe and hit the like button. I post practical guides for business owners every week. I'm Santiago Cueto. Take care of yourself, and I'll see you in the next one.